Order, order, order.
यतो धर्मस्ततो जयः सत्यमेवोद्धराम्यहम्।
The power of law is to punish those who commit offences. It is punitive in nature. But dharma has the power to prevent a man from committing the offence. It is preventive. The word dharma is used to mean justice or nyaya. Dharma has been the cornerstone of Indian society since time immemorial. Dharma constitutes the foundation of all affairs in the world. It has always been given the pride of place in Indian society by our ancestors. Taking this forward, Kautilya in his Arthashastra gave emphasis to impartial judicial administration as one of the ideals of justice. According to him, it is the king's duty as the Dharma Pravartaka to uphold justice and punish the guilty without consideration of position, kingship or anything. Modern-day law in India also draws from Manusmriti, the laws of Manu, the most important and authoritative Dharma Shastra, which served as a foundational work on law and jurisprudence in ancient Indian society. In more recent times, when Britishers started expanding their interests in India, they experimented with various judicial systems in consonance with their own objectives, which acted as the precursor to the present-day judicial system. This was a historic move that left a considerable impact on the history of judiciary in India. The Federal Court's inaugural session was held on 6th of December 1937 in the Chamber of Princes. Its establishment introduced a new element in the Indian civilization, one of the oldest and the greatest civilizations of the world. The first Chief Justice of the Federal Court was Sir Maurice Guire. The Federal Court continued to exist for 12 years. Parallel to this, the freedom struggle was gaining momentum. The seeds of its movement lay in the injustice meted out by the British rule. The British judicial system acted as an instrument to serve colonial interests rather than true justice. This led to Indian leaders, many of whom were masters of law themselves, to push forward with the cause of self-rule or Swaraj, finally compelling the British Empire to leave India. On 9th August 1946, the Constituent Assembly met for the first time to draft a constitution for Free India. The dawn of 15th August 1947 celebrated the emergence of a free nation and the end of British rule. 2 days after India became a sovereign democratic republic, on the 28th of January 1950, the Supreme Court of India was born. The Constituent Assembly conceived the Supreme Court of Independent India as the guardian of social revolution, a repository of all judicial power at the national level. The inauguration of Supreme Court took place in the Chamber of Princes, facing Central Hall of the Parliament building. At the inaugural session, Chief Justice Harilal J. Kania observed that the Supreme Court, an all-Indian court, will stand firm and aloof from party politics and political theories.
We have at last got a court of our own, and there was a great jubilation. Ceremonial opening of the Supreme Court was a thing to remember.
The Supreme Court of India continued to function from the Chamber of Princes till the magnificent new building of Supreme Court was inaugurated by Dr. Rajendra Prasad, the first President of India, on 4th August 1958. This noble edifice was conceived and built in the shape of a balance, as traditionally justice is looked upon as a pair of scales. Thus came into being the Supreme Court of India, the third pillar of India's democracy. The body that has the last say in the most controversial, difficult, yet critical issues in the land. What the Supreme Court decides binds every citizen of the country. It is the upholder of the preamble of our Constitution, the promise to every citizen of the land that justice, liberty, equality, fraternity shall be theirs as a matter of right, that the dignity of the individual and the unity and integrity of India will be maintained. Talking of the Constitution, Chapter 4 makes the provision for a union judiciary. Article 124 deals with the Constitution of Supreme Court, its composition, qualifications and appointment of judges and their office. Article 33 and 129 to 145 of the Constitution give the Supreme Court its teeth. It is a forum of redressal of grievances and guardian of liberties, rights, and final arbiter in most of the disputes, not only between individuals but also between states, the union and state, or between an individual and the state. Article 144 commands all authorities, both civil and judicial, to act in aid of Supreme Court. As an appellate court, it can hear appeal from the high courts on civil, criminal and constitutional matters. It also possesses a special appellate power to permit appeals from any tribunal, court or high court. In the years that have followed after its establishment, this special jurisdiction has dwarfed all others. The court can now even review its own judgments. In its advisory capacity, it answers references by the President of India on any question of law or fact of public importance. Interwoven in these powers is a power of judicial review. The power to strike down such legislation or executive actions as may be violative of provisions or scheme of the Constitution or inimical to the fundamental rights guaranteed by the Constitution.
There is some aura about the Supreme Court which has much to do with the Constitution itself, because the Constitution has, in my view, rightly prescribed that the final interpreter of the Constitution of India is the Supreme Court of India.
Since the ultimate goal of the Supreme Court is to ensure complete justice, it has the authority to pass any decree and order as is necessary for doing complete justice. The Supreme Court of India has the original, appellate and advisory jurisdiction.
Supreme Court has been discharging its duties in the most balanced manner, whereby balance is maintained between the judiciary, executive and the legislature, as well as in balancing the rights of the citizens vis-a-vis the government.
I am proud of our Supreme Court. I think it is a bright shining star in an otherwise dark firmament, and it has kept our country really vibrant as a vibrant democracy and maintain the rule of law.
So who are the people who fulfill these functions in the Supreme Court? The Supreme Court, since its inception, has been nurtured and served by the judicial vision of 41 Honorable Chief Justice and 150 Honorable Judges. The present strength of the Supreme Court judges is 31 Honorable Chief Justice leading a team of 30 learned judges. Smooth administration of courts is also essential for systematic and efficient disposal of work. This is where the administrative wing of Supreme Court, which is divided into administration and judicial wing, known as registry, comes in. It is further divided into various divisions, branches, sections and cells. While the Secretary General is the highest administrative officer of the Supreme Court, Honorable Chief Justice of India is the Supreme Administrative Head. Secretary General is assisted by 8 registrars and 25 additional registrars, deputy and assistant registrars. A typical day in this great institution begins with the meticulous planning. The Chief Justice of India arrives early. He takes stock of not just the cases listed for the day, but also any administrative or other issues that come up. The Chief Justice then chairs a meeting with judges of Supreme Court. This meeting is crucial for the smooth functioning of the apex court. The Secretary General briefs the registrars and the day's agenda is set. Then the honorable judges head for their courtrooms. With this, the ball is set rolling for a hectic day at the Supreme Court. The hustle and bustle outside the courts, with advocates and their parties waiting for the turn, is a common sight. Inside the courtroom, there are some anxious moments, some moments of relief, as honorable judges listen carefully to the arguments. Work does not end in the courts alone. The pursuit of justice is endless. For certain cases, when an urgent action is required, there are no fixed hours. In case of exigencies, Secretary General and the registrars also visit the residential office of the Honorable Chief Justice of India. Hours are spent in preparation at home. It is no exaggeration to say that the Chief Justice and his team of judges put in much more toil than meets the eye. This is indicative of the fact that the Supreme Court is a flexible institution in its commitment to the cause of justice.
Supreme Court has done its best, whatever it can within the resources that manpower, funds and time management. There are some problems of this thing. It may not have kept the the expectations of all the people of all sections fulfilled. But in a substantial measure, it has given people a kind of an assurance that there is one institution they can go to.
A vital functionary of judicial system is the Attorney General of India. He advises the Government of India upon legal matters. In the justice delivery system of the country and in achieving the objectives as enshrined in the Constitution, members of the bar make valuable contributions. They are as much a party as judges in the dispensation of justice. Supreme Court Bar Association, SCBA, is the representative body of the advocates practicing in the Supreme Court. There are three categories of advocates entitled to practice law before the Supreme Court: senior advocates, advocates on record, and advocates who are entitled to practice law before the Supreme Court. Senior advocates are so designated by the Chief Justice of India and the judges with their consent. No advocate other than advocate on record is entitled to file an appearance or act for a party in a court. In the third category are advocates whose names are entered on the roll of any state bar council maintained under the Advocates Act 1961. SCBA also maintains 4 bar libraries in the court premises. Law prescribes for the future based upon the knowledge of the past and to deal with tomorrow's problems, but with yesterday's tools. Knowledge and research is closely intertwined with the commitment to the cause of justice. The Supreme Court Judges Library acts as a research and reference wing of the court. Housing more than 350,000 law books and law reports, it is one of the largest law libraries in Asia. Not just that, it is open on all days of the year, barring 3 national holidays. 18 professional librarians and 70 supporting staff form the backbone of the services offered. The doctrine of precedence is crucial to the Indian judicial system. So citing earlier judgments of the court in support of their contention during arguments is an imperative for both advocates and judges. This is where Library Wing steps in. In the morning, advocates give a list of books to be cited by them in a case. It is the responsibility of the court management section to ensure that the specified book is available to the honorable courts at the time of citation in the court. For the 31 residential libraries of honorable judges, circulation section of the library is responsible for the issue and return of books. On an average, 800 to 900 books are issued per day. Requisitions from the residential offices of the honorable judges are received by the reference section, and this section carries out necessary legal research to cater to the information requirements. Speed is as vital as accuracy in this process. The library has a computer section discharging the responsibility of procuring and maintenance of commercial legal databases subscribed in the library. This section also develops and updates more than 20 in-house databases. Acquisition section looks after the acquisition and technical processing of the books approved by the Honorable Committee of Judges. This section also brings out 2 publications, namely Accession List and Newsletter. The legislation section is the spine of the library. It is responsible for procuring and maintaining parliament debates, legislative materials and gazettes of central government, state governments and union territories.
हेलो ठीक
सुरजीत इलाहाबाद हाई कोर्ट रूल शीट फॉर
एविडेंस कोड नंबर 3 राव कोड नंबर 3 एविडेंस एक्ट
हाँ ठीक है, जल्दी से फ्लैग लगा के हेलो पुरुषोत्तम सेंसस सेंसस एक्ट देना। रामिला जी आईटीसी पे कमीशन 4 नंबर कोड नंबर 4 हाँ सुरजीत दिल्ली हाई कोर्ट रूल्स कोड नंबर 1 4 नंबर।
Complete documentation of acts, amendments, rules, regulations, bylaws and notifications published in gazettes is done so as to retrieve the same expeditiously at the time of requirement at the courts. Mondays and Fridays are perhaps the busiest days as they are Fresh Matters Day. 22 persons work like dancing librarians continuously for 3 to 4 hours to catering to telephonic requisitions for bare acts from the courts. Challenges before the Supreme Court are immense. There has been enormous increase in the volume of fresh cases. The focus in recent times has been on taking steps to bring down pendency. Shedding of pedantic approach is encouraged.
When the pendency is increasing, we have to necessarily raise the rate of disposal also, because it is our duty to prevent the mounting of arrears. Therefore, in that way we are using the computerization as a mechanism to reduce the pendency. Case management systems have been evolved and we are using the computer software and programs which were designed to meet our necessities also in this way.
Computerization has been introduced at all levels in the court under the ICT project. This has helped in minimizing the movement of files. Right from the filing of fresh case till the listing of the case for hearing, procedures have been streamlined and simplified. Fresh cases are filed by advocates at the filing counter. After scrutiny of a fresh case, if any defect is noticed, it is notified online for bringing the same in the notice of the concerned advocate. There is a separate counter for refiling after rectification of defects.
रीफाइलिंग का एप्लीकेशन लगा रहा है।
Subjects categories or case numbers are also assigned to each fresh case at this stage, and files are sent to the concerned sections for listing of the case for hearing. Tagging of cases having identical legal issues is also done after the registration of each case to facilitate the disposal of all the cases as a bunch. Infructuous cases and also cases covered by the judgments or orders already passed by the court are identified and listed before the court for disposal. As a result, the rate of disposal of cases increases and log jams decrease. Certified copies of judgments and orders of the court are provided by the copying branch.
Soon after the matter is registered, the number will be generated, SMS will be sent to the advocate concerned. At the same time, whenever the matter is listed, the listing information will be reached the advocate by email and also by SMS facility. We have started sending the cause lists by email to the advocates, and at the same time we are placing this cause lists in our official website also.
Finding out the status of cases has also become faster and easier. Official publications such as Annual Report, Supreme Court Reports and a quarterly newsletter, Court News, gives an overview of the Supreme Court's judgments and its activities on the judicial as well as on the administrative side, which are of immense benefits for the legal fraternity and people concerned as well. It is also available on www.uphold.org. sci.nic.in, the official website of the Supreme Court. The continuing need to access to justice in Indian society requires adoption of both modern and traditional processes better suited to Indian conditions. The National Legal Services Authority, NALSA, under the Legal Services Authorities Act 1987, is making vigorous efforts to encourage reliance on alternate dispute resolution, ADR methods. Special emphasis has been placed on the organization of Lok Adalats to provide a convenient forum for resolving disputes pertaining to accident compensation claims, family disputes, and deficiency in the delivery of public utility services. The legal services institutions have extended full assistance to the affected people in the following disasters in India. The Legal Services Authority also provides legal assistance to the mentally ill and differently abled people. Honorable Mr. Justice H.L. Dattu, the Chief Justice of India, is the Patron-in-Chief, and Honorable Mr. Justice Tirath Singh Thakur, Judge, Supreme Court of India, is the Executive Chairman of NALSA. The Supreme Court of India has extended its frontiers by taking an active role in judicial training and legal education through National Judicial Academy Bhopal, Indian Law Institute New Delhi, and National Law School of India University Bangalore. National Judicial Academy Bhopal is one of the best judicial campuses of the world. It organizes continuing legal education programs. Judges working in Supreme Court and High Courts update themselves in new and emerging areas of law to serve people more efficiently. The idea is to scale up national judicial education. This can be achieved by creating opportunities for every judge to participate in judicial training for at least 1 week each year. National Judicial Academy Bhopal defines the philosophy, vision and mission of National Judicial System. Honorable Chief Justice of India is ex officio chairman of the Academy. With an objective to cultivate the science of law and to promote advanced studies and research in law and its administration, Indian Law Institute (ILI) was founded in 1956 in New Delhi. In almost 6 decades of its existence, ILI has established itself as a premier institute in the field of legal research and higher education in the country. It offers postgraduate degrees and diploma courses and 2 master courses in law, LLM. ILI has one of the biggest law libraries in Asia, with about 80,000 titles in law and allied subjects. The Indian Law Institute has been granted deemed university status in 2004. Honorable Chief Justice of India is the ex officio president of the institute. Dharmo Rakshati Rakshata. Those who protect justice are protected by justice. This is the motto of National Law School of India University, NLSIU, Bangalore, which was established as the laboratory for experiment in judicial education under the sponsorship of Bar Council of India in the year 1987. On the recommendation of Legal Education Committee of Bar Council of India, the UGC has given assent for the introduction of the 5-year course in law for improving the entry point standard in legal education. Nordic Summer School, a 1-month program is conducted every year at NLSUI students from different Nordic countries like Finland, Iceland and Norway participate to have a better exposure on the human rights legal regime in India. National Law School of India University represents the unique partnership between and among the bar, bench and academia. Honorable Chief Justice of India is the Chancellor of NLSIU. In order to attract young talent to the cause of justice, law students are encouraged to be a part of the judicial process. Once they are engaged as short-term law clerk cum research assistants, they provide assistance in legal research to the honorable judges of the Supreme Court of India. It would not be a very tall claim when it is said that no other judicial institute in the world has acquired the kind of respect, credibility and faith of the people as the Indian Supreme Court. Many foreign delegations visit Supreme Court of India. These visits offer a platform for interaction between the legal luminaries of varied jurisdictions and paving the way for exchanging ideas.
The Supreme Court of India rose to the occasions whenever needed and demanded. Supreme Court judgments are cited in developing as well as developed countries for their quality and jurisprudential value.
Several conferences are organized regularly to aid in the exchange of ideas and views. The Chief Justice of India convened pre-conference meetings with the Chief Justices of High Courts to set an agenda for the joint conference of the Chief Ministers of the states and Chief Justices of the High Courts, and to review progress made on resolutions adopted in previous conferences. The Joint Conference of Chief Ministers of the States and Chief Justices of High Courts was held from the 3rd to the 5th of April 2015. Addressing the conference, Prime Minister Narendra Modi highlighted the importance of the judiciary and appreciated the role played by the Supreme Court of India. The Supreme Court of India, the epitome of justice, has dispensed famous landmark judgments. These judgments have become the foundation of administration of justice system in India. The Keshavanand Bharati case in 1973, the largest ever bench of 13 judges, laid down a new and impressive doctrine of basic structure and said that there were certain inviolable features of the Constitution. There have been moments in the history of the Supreme Court when the impending decisions have been of far-reaching significance. In 1975, the Allahabad High Court set aside the election of Mrs. Indira Gandhi to Parliament. The Supreme Court granted an interim protection for the vacation period of the court. Justice Krishna Iyer declared that Mrs. Gandhi can continue as the member of the Parliament without voting rights in the proceedings of the House. When the government declared national emergency, the Supreme Court was approached by petitions challenging detentions under the Maintenance of Internal Security Act, MISA. The 5 judges bench, by 4:1 majority, took the view that the act passed by the Parliament did not provide for the judicial review of such detentions, even if actuated the balance. The Supreme Court over time has also devised innovative measures to meet people's expectations. One such example is public interest litigation. The Supreme Court attends to grievances from various quarters of citizens through this innovative device. A new jurisprudence was born when several jailmates wrote letters about the unjustified conditions of detentions in jails. The Supreme Court treated these as PIL and acted immediately without waiting for proper petitions to be filed. The Supreme Court over the years has laid down a constitutional discipline within which transgression of fundamental rights and appeals to the public interest would be considered. From saving rivers like the Ganga and Yamuna to shifting noxious and hazardous industries out of Delhi, the Supreme Court has more than once illustrated its commitment to environmental causes. From safeguarding the rights of transgenders to pronouncing the mother as the natural guardian of the child, the Supreme Court has given several liberal judgments. Cases of sexual harassment of working women are a serious offence, and the Apex Court has dealt befittingly with the menace. Child labour is a curse of any society. The Supreme Court has pronounced several orders and directives to the executive agencies to address the root cause of this regressive practice. The court has also left an indelible impact on the battle against corruption. In a recent verdict on black money, the Apex Court directed Union of India to appoint a special investigation team, SIT, under the supervision of 2 former judges of Supreme Court. Similarly, while cancelling the coal block allocations made from 1993 to 2011, the court held that a transparent auction method must be adopted while transferring natural resources. In the spectrum allocation case, it also held that natural resources belong to the people and constitute public property on national assets. So the distribution of such resources should be in accordance with the principle of equality and public trust. The Supreme Court of India has completed 65 years as a custodian of Constitution of India. The contributions made during this journey and its efforts in balancing the diverse interests and upholding the sovereignty and integrity of India are very significant. If the Supreme Court draws satisfaction from its performance, it fully attempts to establish itself in the consciousness of the people of India. And the country firmly believes that it is and will remain stable with justice for all, as long as the Supreme Court of India is in command of the judicial system. The Supreme Court of India indeed stands as a monolithic pillar of justice. Justice at all times and for all, the rich and the poor, the needy and the downtrodden, for indeed anyone who seeks justice. This testimony put forth by the Supreme Court of India has stood the test of time. Today, it towers as a guardian of social revolution, a dedicated upholder of truth and truth alone, and will continue to do so till time immemorial.